SJC-12069, State Board of Retirement v. Thomas M. Finneran.
Mr. Marks, good morning.
Good morning, Your Honors. May it please the Court, David Marks, Assistant Attorney General for the Board of Retirement. This is the Board's petition under Chapter 249-4, seeking review of the Dorchester Division of the Boston Municipal Court's decision that overturned the Retirement Board's implementation of forfeiture of Speaker Finneran's retirement allowance due to his, or based on his conviction of the federal crime of obstruction of justice. And the single justice reserved and reported the case here. The Board's argument, in essence, is that the court committed legal error when it overturned the Board's decision that Chapter 32, Section 15.4 applied to Speaker Finneran's conviction. The legal test, in essence, is whether the criminal offense involved violation of laws applicable to the office or position. Here, the underlying facts regarding Speaker Finneran's conviction show, as this court has said, a direct link, quote unquote, or a connection, or that the offense was related to the office or position.
Can you talk a little bit more about the direct link? I get that there's a link, but
Yes.
direct versus indirect?
Absolutely. Here, there was a direct factual link because Speaker Finneran was intimately involved in the reapportionment process. After the 2000 decennial census, the House and Senate became involved in a process of redistricting House and Senate districts in Massachusetts, and that is under the authority of both the state and the federal Constitution. And in the course of that redistricting process, Speaker Finneran appointed the chair of the House Redistricting Committee, was intimately involved in discussions, developing the redistricting plan. Ultimately, the 2001 Redistricting Act was passed by the House and Senate and signed by the governor. And then there was a challenge to the act by minority voters brought in the federal district court, claiming that the Redistricting Act violated the Constitution and the Federal Voting Rights Act. And originally, that complaint named Speaker Finneran as a defendant in his official capacity. Ultimately, that complaint was amended to only name as a defendant in his official capacity Secretary Galvin. In any event, in the course of the litigation of that lawsuit, Speaker Finneran was deposed by the plaintiffs, and he testified at the trial of the case before a three-judge panel of the federal district court. He and Representative Petrolotti, who was the chair of the House Redistricting Committee, were the only two lay or fact witnesses who testified on behalf of the defense, in defense of the Redistricting Act. And during his testimony, Speaker Finneran lied to the federal court concerning his knowledge of the development of the plan of redistricting that was ultimately enacted by the House and Senate under his authority. And in fact, part of the redistricting involved redistricting of his own House district.
So is your point that violation of laws applicable to the position, it's not you're saying it's not, you have to look at the factual circumstances, not just the law. Is that?
Absolutely.
That's your answer to Justice Budd?
I guess so. That was the long answer. Yes.
I mean, that's where you're
Absolutely.
going, right?
Absolutely.
Is there any distinction between the fact that he was not a named defendant, or no longer a named defendant, and was a fact witness in this case?
No, because what he did in this case had everything to do with his office or position, his status as the Speaker and as a member of the House. To go back to your point, Justice Botsford, I just want to make clear that as this court has said in Garney, there are sort of two branches of analysis, two independent branches of analysis under 15.4 that sometimes might merge. One is the question, and they're like I said, they're independent. One is the question of, is there a direct factual link between the office and the crime? And the other question is, separate question, alternative question, is there a violation of the fundamental tenets of the position as a result of a violation of the laws applicable? And that is more of what I call a legal test. So the cases that are an example of that really are, the best one is Bulger, in which Bulger's crime had nothing to do, factually, with his office or position. He committed perjury before a grand jury in a matter having to do with his knowledge of the whereabouts of his brother.
Isn't that case distinguishable because he was a clerk magistrate and he had a special code that he had to follow?
Yes, I'm not saying that this case is exactly like Bulger. All I'm saying is that there are these two separate modes of analysis. Here, the board found that both applied. We press the argument, because it really is the easiest one for your honors to rely on, that the crime and the office are directly linked because of the facts. Everything he did here had everything to do with his position as Speaker and as member of the House. He testified while he continued to serve as member and as Speaker of the House. He testified in defense of a law that he was involved in developing and enacting. He testified about and based on his own knowledge of what happened in the course of enacting that law. And as a subsidiary purpose, he said, this is at page 289 of the record, during his plea colloquy, at his guilty plea, he said he was motivated in part to testify falsely because he was angry at the implication that the lawsuit carried that he had engaged in some deliberate racial manipulation to suppress efforts at legitimate efforts at minority representation. And this, of course, would be important to him as a person who might seek re-election from his own district. So the bottom line is that everything he did here and everything that happened only had to do with his office or position.
Could they have proved their case without Speaker Finneran's testimony? Was it essential to the case that the voters pressed in the federal court?
Well, he testified as a defense witness, defending the act.
Well, yeah, I'm sorry. I shouldn't have put it that way. I just mean to say, was his testimony necessary for any party in the case? It doesn't matter who's...
It's hard to say. It's hard to say on this record. He clearly felt it was necessary because he was one of two defense witnesses, lay defense witnesses, defending the constitutionality and the validity of the act.
He testified voluntarily, right? Not pursuant to a subpoena?
As far as we know, he testified voluntarily. That's right.
Certainly, he argues that he did.
I'm sorry?
That's one of the points that he makes, is that it was voluntary and not in his official capacity or anything like that.
Well, First of all, it doesn't matter, because everything he did only had to do with his office or position. He was defending a law that he was involved in enacting, and he was defending that law against an attack on it. But
So if he had testified in a civil matter that had nothing to do with the legislature, or in a criminal case that had nothing to do with the legislature, are you still here?
that's a totally different case, Your Honor. That's a totally different case. It certainly would not carry the direct factual links that we have here. No question about it. That's what's important about this case, is that as one of the highest officials in state government, he lied to a 3-judge panel of a federal district court that was reviewing the question of the legality of a state law that he was involved in, intimately involved in, as Speaker and as a member of the House, and his false testimony was given while he continued to serve as Speaker of the House and as a member.
I just want to press a minute on the connection between his job and his testimony. I mean, you can see a set of circumstances where a person does something because he has to, because it's his job to do it. That is pretty clear. But in this case, I'm gathering that he didn't have to testify if he did it because he wanted to. Is that the same, does that present the same kind of factual complicity that the other situation does?
Yes, absolutely. He took it upon himself to testify, to defend a law that he was involved in as Speaker and a member of the House, and that he chose to defend that law by testifying falsely.
So the law is not intended just to reach people who do things as part of their office because they have to. It also reaches this other category of acts where a person decides that they want to do it.
That's right. Well, in most of the reported cases, Bulger, Durkin, Marr, these are both SJC cases and appeals court cases, the person is not doing things that he's forced to do. In Marr, Marr broke into City Hall in the town of Quincy to steal something out of his personnel file that he thought reflected poorly on him and that risked his not being reappointed by a new mayor. I mean, he had no duty to break into City Hall. He was not forced to do that, and he had no specific duty not to. So the court has been very clear in Gaffney, one of the early cases the court decided. The court has been very clear that the precise form of the criminal offense is not what matters. What matters is there a direct link between the facts and circumstances and the crime and the office?
What do you say about the Eighth Amendment argument?
Well, what I first say is it was waived. The Eighth Amendment argument was never raised until Speaker Finneran's brief filed in this court. He originally filed a petition in the district court challenging the forfeiture, and there was no mention whatsoever of the Eighth Amendment argument. The only assertion in the petition was that the forfeiture generally violated his rights under the Constitution.
Okay, but he won in the district court. And Betancourt hadn't been decided or it was decided after Judge George's opinion, correct?
Well, there were plenty of cases in which the excessiveness issue had been raised before so that he was on notice that this was a viable issue. McLean, Marr, all of these cases hadn't been decided already. So that's the first problem is he's waived it. The second problem is that there's no fact-finding on the underlying issues regarding excessiveness, and the board has been prejudiced by not being able to offer facts.
But why, I guess the question is, why wouldn't, if you're correct on that forfeiture is appropriate under the statute, why wouldn't it have to go back to deal with that other issue?
Well, all of the cases, I believe all of the cases that an appellate court has addressed the excessiveness issue have had the benefit of some fact-finding or determination by a lower court. So yes, Your Honor, at the very least, the case would have to be remanded for the district court to hear evidence and make factual findings on that issue. And finally, the case is nothing like the Betancourt case. Speaker Finneran was convicted of the federal crime of obstruction of justice. It carries a maximum sentence of 10 years in prison under 18 U.S.C. 1503. It carries a maximum fine of $250,000 under 18 U.S.C. 3571. The courts have been very clear that what the sentencing guidelines are and what the sentence actually was is entirely irrelevant. To determine the seriousness of the offense, you look at the maximum penalties. This was a serious offense committed by a high public official in public by lying to a federal district court. And if you look at the proportionality between what he loses, perhaps roughly $500,000 worth of a pension, versus the seriousness of what he did, the fact that he undermined public trust and confidence in state government, the case is much closer to those other cases, McLean, Marr, Flaherty, in which the forfeiture has not been found to be an excessive fine and different than the outcome in the Betancourt case. I see my time is up, so I would ask you to reverse the court's decision, and I rest on my brief. Thank you, Your Honors.
Mr. Poser, good morning.
Good morning, members of the court. May it please the court. I appear today before you on behalf of Speaker Finneran. With me today is Thomas R. Kiley. The facts are very important in this case, and I agree with my brother that the analysis is almost purely dependent on facts. And the facts, I think, that are important are, in a sense, both historical and slightly more present. The historical facts are that while he was the Speaker of the House, Speaker Finneran, Mr. Finneran, was intimately involved in the crafting of the Redistricting Act. That 2 years later, when he was testifying, he happened to be Speaker. And while testifying, he was untruthful to the court. And those two things do not connect into a direct link that creates, that supports a pension forfeiture.
Could you repeat that, because it went by me?
I'll try to be as clear as I can. This case is like nailing Jell-O to a wall in some ways, because Speaker Finneran, the connection to his job, if you will, took place before the crime. He was definitely involved in the Redistricting Act. There's no question about it. But when testifying about the Redistricting Act, he happened to still be Speaker, but he was not testifying in the role while presiding over the House. That's what you have to show, or have to have. You have to have the idea of official acts that are, or in official capacity, or that the official capacity, the Gaffney case says that you have to show a direct link between the conviction of the crime and the official capacity. And that's not happening here.
I mean, when Mr. Marr broke into the Quincy City Hall, that's where it was, he's not there in his official capacity.
Certainly not. And what this court has said is that there are certainly, you have to have a direct factual link or direct link to the job and the position. So in Mr. Marr's case, the, the link to his job is that his employer was his victim. He stole from his employer. He broke into the city hall to his employer. So you don't, but the official capacity was the plumbing and gas inspector. And I've tried to stay away from the idea of motivation, because I don't think motivation is important, but I will agree with my brother that he was certainly motivated to try to keep that job. But there's no corollary motivation with Mr. Finneran here. His motivation, whatever it might have been, is not part of the elements of determining pension forfeiture under 15.4, which has to be narrowly construed.
Well, his testimony wouldn't have been relevant if he hadn't been speaker, right? I mean, that was what made it important to the case.
It's
was his
relevant because he was
position.
speaker at the time of the Redistricting Act, not at the time of his testimony. Had he not been...
That make a difference.
It makes an enormous difference, because you have to show that while he was testifying, he was doing something that was related to his job. And there's nothing in the duties of a Speaker of the Massachusetts House, or any member of the House, that implies you have to go testify about the crafting of a statute. It's the furthest thing from the duties of a Speaker.
Where you're getting related to the job as opposed to a direct link. I know we're parsing words,
the
but
cases-
obviously, as Mr. Marks said, when Mr. Mara broke into Quincy City Hall, that wasn't related to his job.
Well, the formulation, well, it is, because he was
the gas inspector, not the official B&E guy, right?
not being from Quincy, I don't think that they have that position.
I am from Quincy,
We're
but go
talking
ahead.
about people that live in Quincy around here.
Indeed, and my brother is also from Quincy.
City of Quincy, right.
The cases speak of all sorts of connection words in direct link, direct factual link. I think Garney uses direct factual link. Gaffney uses a direct link. The gravamen of if there are elements, the elements are as follows. And the Garney case lays it out as clearly as I have been able to see it, and I've been doing a lot of these over the last 15 or 20 years. That if you are not convicted of a violation of a statute that references public employment or public office or something like that, Hobbs Act is probably the only thing that comes to mind off the top of my head. Or if your crime wasn't committed at work, in essence. And I think the Garney case references that Durkin doesn't matter. Durkin is the police officer who shot someone off duty, but he was using his service weapon. Or if you're not using the resources of your department or your position to commit the crime, then, and only then, do you then look at laws that cover that position. And in this case, in essence, the State Retirement Board took the pension away on the idea that Speaker Finneran, that the sort of everything surrounding him was about being the Speaker of the House, but almost nothing that connects to the actual crime that he committed connects to the Speaker, being Speaker of the House.
Would he have been there if he were not the Speaker of the House?
No, I think you're right. He probably would not be that he wouldn't have the knowledge. He wouldn't be a relevant witness.
So that's the answer, isn't it?
No, it's the opposite of the answer, because the thing that you have to look at is at the time of commission of the crime, was he, beyond having the status of Speaker, happened to be still Speaker or a member of the House, did he do anything that connected him to his job? And sitting in a witness chair in the federal court, testifying about what happened 2 years earlier, is not a duty of the Speaker or member of the House of Representatives.
Am I correct that based on your argument, a legislator could never be denied or have his or her pension forfeited as a result of testimony in any court?
No, that is not my argument.
When would false testimony in a court justify forfeiture?
I'm sorry, maybe I misunderstood your question. I thought you were asking, would he...
I'm saying that I'm hearing your argument to say that false testimony in a court by a legislator can never justify forfeiture. Is that your point, or do you think there
No,
are
I'm sorry.
circumstances in which it
There
could?
certainly are circumstances.
Okay,
but-
and then the
but
question is,
because they have to
tell me
make the-
those circumstances in which false testimony
Well-
in a court could justify forfeiture.
If the testimony was in something that was unrelated in any way to his legislative, to the sphere of his legislative activity, if he's, testifying falsely in a libel case or in some personal case, you could lose your pension just like anybody else if there is an other connection to the job. See, again, we're getting into this mushy area.
The question is there any circumstance in which a legislator is testifying in a court and lying that would, because it's not in the job description of a legislator to testify in court, does that mean that you could never convict a legislator in any circumstances for that act of lying, of testifying falsely?
Well, I think I have to give a qualified answer, because if the legislator is testifying in his official capacity, because he's a legislator, he's in court testifying. And just for the sake of discussion, let's just say that Speaker Finneran was. We say he wasn't. Then you get into the area of the speech and debate clause. And the speech and debate clause, and I'm not sure about perjury, but it's certainly, the speech and debate clause is as clear as you can get, that nothing that a legislator does within the sphere of his legislative activity, I'm using that term from the Coffin v. Coffin case of 1808, it says it's a very broadly construed constitutional provision that protects him from any kind of, at least state, negative consequence.
Doesn't your qualifier, you're not sure about perjury? I mean, it seems to
Well,
me
because he certainly was convicted of perjury. There's no question about it. And I don't think that was a defense. He pled guilty to that, so we're not making that claim. But if the legislator is in court testifying, and again, we've spent a lot of time in our brief discussing how unusual that circumstance is, but if somehow they were testifying in court and putting us, but again, perjury, again, obstruction of justice, is not necessarily related to the legislative activity.
Okay, I'm going to try my question again, because you still have not answered it, and perhaps I've not been as clear as I could. Is it your position that testimony by a legislator in court can never result in the forfeiture of a pension?
If he's testifying in court in something that relates to his legislative role, speech and debate clause insulates him from pension forfeiture because of separation of powers.
But here, he did not invoke that. He voluntarily testified.
Indeed. And
So
I think,
where one voluntarily testifies and testifies falsely, is it your position then that the speech and debate clause prevent any consequence arising from false testimony?
yes. And again, it's a difficult analysis, but the speech and debate clause, as best I understand it, has a testimonial aspect, meaning he could have defended against being subpoenaed, but at the same time, testifying, the speech and debate clause still insulates him from a negative consequence in state court, such as this one, or in the state. And the speech and debate clause talks about in court or any other place where it says basically nothing can happen with regard to something that is said within the sphere of legislative activity. And I will grant you that testifying about what he did, or what he knew, or actually he barely testified at all. He just basically said, at least what he pled to is, I didn't see the plan until anybody else saw the plan. That's not necessarily a huge aspect of the legislative activity, but it is enough. But there is a difference, I guess, is what I would get to, is there's a difference between performing the duties of a legislator and being within the sphere of a legislative activity. I think the sphere of legislative activity is much broader, and the speech and debate clause covers broader and insulates more broadly than the narrow analysis of what would happen if you were testifying in the official capacity, which we do not think he did.
But based on what you just said about the speech and debate clause, why then was he convicted of obstruction of justice?
Again, the speech and debate clause, insulates him from, I would imagine, or the way and I wasn't raised in the federal court as a defense, but the speech and debate clause didn't insulate him from testifying falsely to the federal court in that case. And I think that's as far as I'm willing to go, because I didn't research it much broader than that. Let's talk about him being the speaker. And one of the things that the cases have seemed to push back against retirement boards trying to expand the scope of retirement forfeiture is where there is someone who has what is perceived to be a position of special public trust. Police officers, firefighters, teachers, and I think that the State Retirement Board is asserting, in essence, that where you have this very high public official, he has a special duty to be true to the Commonwealth, to defend the law that was passed, and I think that is improper. I think that the law applies, and the court keeps saying in Bolger, in Garney most recently, that the law, this pension forfeiture law, applies to everybody equally. Whether you're a police officer, whether you're a firefighter, whether you're a teacher, whether you're a legislator, there's no special status, even if you could be fired or even if you could be disciplined for the conduct that you are ultimately convicted of within the sphere of your high public trust office, which you cannot do that with the Speaker of the House, obviously, that you still have to show that there's a direct link or that there's a law that covers you, that covers your position.
Could I ask you, if you, let's say we don't agree with you, that we think that, in fact, this fits within 15.4. What do you say to Mr. Mark's argument that you've waived any claim for a sort of Betancourt claim?
Eighth Amendment. There's no case that I've seen that says what, in fact, you have to do to preserve your rights. You can't litigate the Eighth Amendment in the Retirement Board. That we know that from the first mayor case, I believe. They don't have power to decide constitutional questions. Only a court does. The rights, I think, were preserved quite adequately by, in the complaint, by saying that the Constitution was violated by the pension forfeiture. And then the third thing is the Retirement Board, maybe they didn't make findings of fact. I don't know if they were asked to make findings, but they're certainly in the record. And there's the only thing that the district court would have done is to have testimony from the Public Employee Retirement Administration actuary as to what the present value of the pension was when it was taken away. You have that in the record. In the appeals court decision in Betancourt, where they took Lieutenant Betancourt's pension away, the court just then remanded to the district court for findings on questions of the Eighth Amendment. You don't need to do that. You have it in your record already. And I see my time is up. I will rest on unless any other questions.
All right, thank you.
Thank you.